Welcome to the Rational Egoist. I'm your host, Michael Liebowitz. Well, unless you're living under a rock somewhere, you know that the Colorado Supreme Court has declared that Donald Trump is not eligible to be on the ballot for the primary in Colorado. So everybody's up in arms about this. People feel strongly one way or the other. I've come across a lot of different scholars who think differently on it. Today we have somebody on to break it all down for us. He is the Peter and Kirsten Bedford Senior Fellow at the Hoover Institution. He's the Lawrence A. Tisch Professor of Law at New York University Law School, and he's a senior lecturer at the University of Chicago. He's been here before. He's our favorite classical liberal, Richard Epstein. Welcome back.
It's nice to be here with you, Michael.
So there's a lot of different takes that people are having on this. So I've come across three that I find especially interesting. Of course, if you think there's more we need to get into, feel free to break it down. But we've got this question of whether or not the presidency is an office under the United States of America. We've also got this question of whether the 14th Amendment, Section 3, is self-executing, which I'd never even heard of until the other day. And then we have the question of whether or not the right to run for president comes with a liberty interest, as is described. The right to you have to have due process to be deprived of your right to life, liberty, or property. So I guess we can take them whatever order you want, or you can explain whatever you think needs to be explained. The floor now, sir, is open to you.
Yeah, okay. I think what one has to do is actually start at the top with respect to the provision in question
Okay.
on Section 3. I won't read it now, but it begins with a discussion of particular people, senators, congressmen, and vice presidential and presidential electors who are subject to this, as well as to officers of the United States. And so the first question you have to ask when you're trying to figure out whether or not the president is covered, why is it that you have the electors for the president being covered and the president not being mentioned explicitly? Is there any rhyme or reason to it? And it makes perfectly good sense once you understand how the Electoral College works. The great fear that you have with all four enumerated classes is that they are chosen by the electorate of a single state. And if this was a revolutionary state or secession state, the danger is they're going to try to populate those people, put those people in these key national offices. So if in fact you have an insurrection ban, it's very easy to enforce in 1866. The question quite simply is, will you remember the Confederate Army or the Confederate government in some way, shape, or form? Those things are pretty well known. If you will note that the Article 14th Amendment, Section 3, doesn't even have a procedure for determining what is or is not an insurrection, right? Because in those cases, it was pretty trivial. So what happens is you want to get those guys out. Now you get them out, and it's pretty easy to figure out who they are. At this point, you have a sanitized Congress, which can now do business in appropriate fashion, and you have a sanitized electoral college. So there's no need for any further intervention. Having cleaned up the electoral college, it means that the presidential election could go forward, which is why it is they did not put the president in that particular point. He's going to be chosen by a national party selection process of one kind or another. And as that starts to take place, if all of the particular states are in good order, there's no reason to have anything whatsoever about it. The second thing is you look at the last part of this, there's a way of waiving the situation with respect to disqualification by an insurrection, and that's by a vote taking place in the Congress. Well, this makes no sense in connection with the president. If he's chosen by the Electoral College, how are you ever going to put that process into place? So you can never figure out what the waiver provisions would work given what's going on here. So that's the second kind of anomalous type situation. And so essentially then what you have to do is to say, well, for whom could you do this? Essentially, it would be either the people who are elected in the first group that we've mentioned, or people who have offices. Now, you basically said, is the president in office? And the answer is the presidency is in office, but the president is not an officer. And this difference without the R is actually very important if you look at this thing more systematically and structurally. Everybody says, of course, the president has to be an office, or because the executive office, right? Then he's got to run that. But then what you have to do is you have to look at the appointments clause. And the appointments clause says, essentially, we give you a way to appoint people. It's a complicated clause. It's in Article 2 of the Constitution. And the first thing it says is there are certain offices that the president can appoint, but only with the advice and consent of the Senate on his behalf. And those are what we would call major offices, or they don't call it that, they just call these people. And then there are inferior offices, which could be appointed either by the president or the heads of departments or by the courts. And so what happens is when they say all executive offices are appointed by the president, they can't mean the president's appointing himself. What they mean under that provision is these are appointive officers. We have all sorts of safeguards, one of which is that the legislative branch cannot appoint any executive officer. It has to be done either by the courts or the executive branch. And so therefore, the president is not an officer because he's not appointed under those particular situations. The appointments clause, by its own internal construction, cannot apply to him. And so it follows he's out from underneath that situation, and that means he could run. And so when they said, you know, even with impeachment, he's thrown out and he can't have office under the United States, the impeachment clause does not say he cannot run for re-election, which he can't. And the theory would be if the nation itself wants to sanitize the president of what they think is an unjust impeachment, they're entitled to do so. What he has done is he's subject to further punishment if, in fact, he is convicted. One of the things that is going to come up, and I'll mention it just in passing here, is what we did is we had a trial, right, for the president, impeachment. And it's kind of a mix between, was this an insurrection case, an incitement case, a bunch of other stuff. He was acquitted. And so the question then is, if you're acquitted in a criminal proceedings, which this surely was, does that mean that you cannot be prosecuted again by another branch of the federal government because of double jeopardy? Judge Shotkin answered that question in the positive. She could be prosecuted. I think she was just dead wrong. I think the first case is essentially res judicata, and you can't go after it again. And so when Jack Smith wants to do it and relitigate things that have already been litigated in the Congress, I don't think that's possible. So all of this stuff together says that essentially the president is not an officer. If you start looking at what they wrote in the Colorado opinion, the most striking feature is they never mentioned anything about the appointments clause, just not mentioned. What they do is they keep on giving you illustrations where they talk about the office of the presidency. They don't give you a single sentence where the president is described as an officer. And, you know, this is all constitutional pedantry at one level. But when you're looking at a doctrine, you have to kind of integrate what takes place under the various amendments with the basic proposition and position that you have on the individual clauses. And that's why the appointments clause is so absolutely critical in this situation. So I think that this is clearly a reversible error. Now, that is one question that we have. And if you have any questions about it, I'm happy to answer them. But the arguments that I've heard on the other side are just sloppy. What they do is they kind of look at the word officer. They say, well, president's an officer, kind of. Well, do it. They don't explain how it is the beginning of the clause. And so essentially, when you get most of the summaries that are given to this provision, they all say it applies to any person. And they don't go through the initial words. And when you're doing constitutional interpretation, there's no shortcut. You have to make sure that every word and every structure counts. So I think that they should reverse on that in the Supreme Court. I might add that this argument was raised early on in the game by Michael Mukasey, a former district court judge and attorney general, a very smart man. It wasn't even discussed in the Colorado opinion. That is what's striking about it is there's not a single article that is cited there or a single reference which takes a contrary view. My good friend Jack Blackman wrote an exhaustive response to the article written by Will Bode and Michael Pawson. Never mentioned. Never mentioned. And so I think, in effect, this is a very unfortunate situation. And when you hear the Democrats announcing they always want to make sure that the sanctity of democratic processes are going to be preserved, and then they try to make this very dubious argument to circumvent democratic processes by saying democracy has to be protected by somebody, and then it's all editorial. You can't find a single person who is in favor of Donald Trump being disqualified for an insurrection will not follow with, which will allow the American democratic process to avoid the disaster associated with Donald Trump. They don't say what you're supposed to do about the disaster associated with Joe Biden. And I think on this point, it's just not what our issue is. You could dislike both candidates intensely, which is generally my preferred position. And then you have the usual problems. You choose between them on the grounds that there's a lesser evil, or do you say there's a level below which I will not go, so I won't vote for either of these things? I tend to be a lesser evil guy because I think if I could do better than worse, I'd rather do better, even though better is no good. And so if you're in the negative territory, I'd rather be at -4 than -9. And so I will do that. But, this is the kind of philosophical issue on which it's very hard to explain to other people who have sovereign control over their own vote. So that's what I would do with respect to the first question. And I think that ends the case. If
Okay.
he's not covered, nothing else matters.
So I was listening to a podcast with William Bode, and he was asked about this very issue about the office or if it's an office. And he said, if you look at the legislative history, and he said during the discussions about this clause, this actually was discussed. And somebody, I don't remember the guys' names now, but they basically they said, of course it applies to the president. It's not even an issue.
Well,
First
I
of all,
look at, I
does
regard
the
all that stuff as worthless.
okay, that's what I was just going to ask you. So because it's atextual, it's outside of the text, you would say it doesn't matter
It's
at all.
also, it represents 4 people, 7 people. I mean, Nino Scalia had, I think, a fairly good intuition about how you read text, which is you basically read it as written. And the only things that you imply are perfectly standard norms that apply to constitutional interpretation, independent of the concerns of voicing of a particular president. So to give you an illustration, the 14th Amendment and that discussion doesn't talk about anything about the police power. In fact, the Constitution is absolutely barren in any discussion about the police power. If you look at the names of the treatises, including those put together by Mr. Cooley, a great judge, in 1868, the year of, of the 14th Amendment, the title of the book has to do with the police power limitations on constitutional rights. Well, where do you get the police power? You can't get it from that kind of discussion. What you get it from is a well-awareness if you have a prima facie right, say free speech, doesn't mean the right to essentially tell somebody to assassinate the president. So you'll start looking at this stuff. Oh, Congress passed no law abridging the freedom of speech. And then we decide, oh, the law of criminal conspiracy is hereby repealed. The law of fraud is hereby repealed. The law of defamation turns out to be repealed. The law of intimidation turns out to be repealed. So they all involve speech, right? Oh, no, they involve conduct. Well, they involve speech and conduct. Who knows what the difference is? But the point is, you can always restrict that speech, which at the very least violates libertarian norms. And so where do you get that? You get it from an implication of what it means to talk about freedom and realize it's different from license. So the correct mode of constitutional interpretation never depends on these piddling discussions taking place by people. The discussions take place early, sentiments change and all the rest of it. And if they say, of course, the question you then have to ask, well, then why did they structure it in this particular way and not put his name in there to begin with?
Fair question.
Well, it's absolutely insane. If you manage the electors and put them in there and you don't mention the president, is this just a gaffe? They didn't quite understand this. And then you have to imply, no, it turns out I gave you a perfectly good structural reason as to why it is that you're very concerned about electors who are done by individual states, as opposed to the presidency. When you sanitize the electoral college, getting rid of all these guys, it now runs just as it did before the Civil War, which is what they were after. So I just think it's wrong. I mean, I regard this whole thing as a kind of a massive sort of absurdity. I mean, we do have stuff, we'll get to upset, insurrection as to how they work. I could talk about it later. But I think the case is over here. And then you said your next problem, right?
Well, you gave me something I wanted to ask you about. I was just looking for it, but I couldn't get it to come up quickly. The Fifth Amendment is where the double jeopardy clause is. I can't remember off the top of my head exactly what it says. Do you know?
No person shall be put twice in jeopardy of life or limb.
Okay. So my question is, how would a acquittal of an impeachment, which doesn't put anybody in jeopardy of life or limb, apply? How would jeopardy attach to a criminal case?
Okay, obviously what happens is you take an ordinary civil case, and if it only applies to cases of capital punishment or torture, it doesn't apply to ordinary criminal sentences. So nobody has ever read it as limited to those cases. A fine, for example, or incarceration would be sufficient to attract the clause. This is a kind of metaphorical type situation, but it becomes utterly absurd to assume that you can have double jeopardy if you want to send a guy into prison for 50 years. And you lose once, you could try two. And remember, if you can do double, you can do triple jeopardy, and so forth. So essentially, nobody has ever read it in that particular fashion, and that's correct. And so what happens, they call this a criminal trial. And if you get
Impeachment
acquitted,
is a criminal trial?
that's the way it is. Read it. I mean, the whole thing talks about criminal proceeding. And so the only way in which you can make comfort out of this position is to treat it as though it's a criminal trial. What it does is it says, here we do have a double jeopardy provision that is eliminated, because if he is convicted, we don't want this body sentencing the guy to death. We want to get him out of office, and then we particularly preserve the right to pursue further punishment. There's nothing said in the clause about acquittal, right?
Well, yeah, but that's the whole thing. If he's convicted once there, but in the exact rule of impeachment, he can then be tried criminally.
That's right, because it's
why wouldn't
exactly
jeopardy attach there? That doesn't make any
because what
sense to
happens
me.
is an explicit exception that's built in. You limited it's very rare that you limit the punishment at stage one. You limited it at stage one, and we know why they did it, because they were afraid of political hangings, which often happened in England. And so what you then do is you say, you got to go into court and you get your standard judicial procedures. But if you're acquitted, the correct answer is to say you've done nothing wrong, and you can't start again in a court to deal with this. And so when Judge Shotkin said, oh, acquittal doesn't mean that we can't try him again, she's just wrong. I wrote a column about that on the Hoover site just the other day. This thing was put together very carefully, and it doesn't talk about the case of acquittal. So what you do is you have to apply the general rules, what happens in the federal system with an initial acquittal. And it turns out that you can't bring a second suit in the state courts, as she notes correctly, but it's irrelevant here. And the double jeopardy clause is never applied across platforms. So if you're acquitted on a federal crime, you could still be tried in state court for the same offense. And there are many people like myself who are uneasy about that. And the explanation is federal and state judges or federal and state prosecutors often collude. And so you take them first, and if you don't get him, then I'm going after him. It all of a sudden looks a little bit nastier than they would if these two bodies were completely autonomous. And that issue is still contested. Is it a different offense if it's being sued against a different sovereign? And the answer given to date is that. But I think she's just wrong on this question. It's a criminal proceeding from start to finish. You cannot bring impeachment for a civil action like for a divorce or something like that. The only justification is that. And by the way, in the Constitution, it doesn't require that the president be removed from office if convicted. It has to be convicted of a treason, felony, or a high crime and misdemeanor.
Yeah.
I mean, and that's where it comes in. The impeachment clause is in Article 2, and earlier on in it, and this thing is the last section that takes place with respect to executive power. So it's quite clear they understand how the whole thing begins. And remember, on the House side, it says the House shall have the sole power of impeachment. That's the last word in Article 1 about the powers of the House of Representatives. And of course, when they mean sole power of impeachment, they mean it's a criminal proceeding. I mean, there's never such a thing as it were, a civil impeachment trial. It's almost like a contradiction in terms.
Okay. So back to the case at hand.
Yeah.
The next thing I wanted to talk to you about is just, I've never heard this before, this self-executing aspect. But there's debate over whether the 14th Amendment, Section 3 is self-executing, because I guess in Section 5, it says Congress may enact legislation or some such thing as that.
Congress shall make appropriate legislation.
Yeah. Okay. So is, in your view, first of all, what does it mean to be self-executing, and is Section 3 of the 14th Amendment self-executing?
Well, Sections 4, 3, and 4 is decidedly not self-executing. So something is self-executing if you pass a law and you say, for example, that Michael Liebowitz is now a citizen of the United States. At that point, he's a citizen of the United States, and there's no need to pass any legislation to confer upon him that particular status. So what the Constitution does is it works to change the status independently. When you start dealing with things like that, it's okay on citizenship law. Now, the problem trying to apply that to this case is that if you're talking about an insurrection, what happens is you have to know who has been involved in that particular thing. And simply passing a clause which says that we're going to get rid of somebody who has been participated in an insurrection is going to require at least some determination that he be involved in it, which is why it is that the 14th Amendment has that last savings clause to exempt people from it. Well, in this particular case, it clearly isn't self-executing. You have to have some kind of a procedure to decide whether or not Trump or anybody else is or is not an insurrectionist, right? Now, in most cases, it's easy because the definition of insurrection bears no relationship to the sort of the simple use of force in defiance of law. It's basically an effort by force and arms with an organized force to get rid of you. So I was reading on another project, all of the stuff having to do with the Spanish-American war. And in it, there turns out to be the United States has conquered the Philippines, right? Admiral Dewey sails into Manila Harbor, and all of a sudden we own it. But there's an insurrection going on, a real insurrection. They got a general, they got a bunch of people out there, they're fighting, they're attacking, they're killing. It's not 3 hours at a park. And so what does McKinley do? He sends a letter to Elihu Root, who's the Secretary of War at the time, and he says, I want you to stop this. This is an insurrection. You have to put it down. And then when you put it down, what we're going to do is to figure out how we manage to introduce up-to-date norms to govern this place. The white man's burden under the so-called, imperialist doctrine, although it was an amazingly benevolent imperialism to that. That's what an insurrection turned out to be. Okay, and now you look at this case, you got 2 hours, half the people are milling around there doing nothing. You don't even know who's pushing them in. What they do is they accuse Trump of engaging in insurrection when he tells them to go to the Capitol building, but they don't say, oh, did he tell them to go in and to throw people over? Well, the answer is he did nothing of the sort, right? He said, go there and fight to defend your rights. That's perfectly consistent with them screaming and yelling outside. And well, who pushed them in there? Well, was it Ray Epps, who got a sweetheart sentence? Were there other people who were doing it? Did the doors open by somebody else? So A, it's not clear that this thing counts as an insurrection. It doesn't, in my view. It counts as a kind of a police upset type situation, a criminal trespass. And if it's not an insurrection, he didn't engage in it. And if it is an insurrection, it's by other people and not by him. And so, I mean, you just start looking at all this stuff. To say that this thing is self-executing means what? Is that now we've passed the 15th, 14th Amendment and we know that he's an executor? No, somebody has to decide that. Well, who's going to decide that? Mm-hmm. Well, the remedy that we typically had is you get your elective office, the appointed office, and they turn you out. In this case, this self-executing provision is going to require 50 different states with 50 different set of procedures to make 50 different determinations of what's going on. That's not self-executing. And so if you say the clause is not self-executing, it certainly can't mean that everybody does that. You don't know what you're supposed to do. So what it is it is self-contained. It has fundamentally different characteristics from the first clause, the second clause, and the fourth clause. I mean, it's just a very different product, and it isn't self-executing. So what the judge said, following Bode and Paulson, is, well, the other clause is self-executing, so this one is as well. And the other point, of course, that you made is, wait a second. Even this self-executing stuff is very strange, because if it's all self-executing, why does it have a provision in Section 5? Congress shall have the power to enforce this constitutional amendment by appropriate legislation, right? So, I mean, we have this very kind of dicey feature of some of it's self-executing and some of it's not. Now, why do you need the second clause? Well, somebody's made a citizen. And it turns out a bunch of revanchists and terrible Southerners come along and say, you may be a citizen, but you cannot vote. We're keeping you out. Well, at that point, you got to bring the feds in order to basically enforce the right. So the right is automatically conferred upon you, and the enforcement is brought in there to make sure that if somebody tries to take it from you, you're going to have an adequate institutional response. So we can't do it. But it's just misreading this clause to assume that every local official can do it. Then, of course, what's going to happen is you knock them off the ballot in one place, decide that you don't have standing in another case, right? Because there's one guy named Castro or something who's brought about 15 of these lawsuits. They rejected him in Virginia. You can't run a system of a divided authority. It has to go to the Supreme Court. And it comes there in the most inauspicious circumstances. The Court of Colorado decided, without any proof, that the time to take him off the ballot was now. There's nothing about the 14th Amendment says now, is there? So if you take them off now and then you reverse, there's no way to reverse the election. So the courts who said, I think it's an insurrection, said, this is not the time to do it. We'll see whether or not the guy wins or loses the primary. Because if he's out, he's out. And if he wins it, then we'll have to worry about it, but we'll have more law to decide this. Taking it out at this particular stage means there's a horrific risk. He's off the ballot, and then the court is overturned and you can't get him back on the ballot. So it's crazy. And they didn't care about that. And then the Supreme Court's going to take it. Now, what is it going to do? God knows. But one of the things it could do, which I think would be catastrophic, is to say this is a matter of federal law, not a matter of state law. That's not even clear, but let's assume that it is, right? Because state law determines state election. And then what we do is we think that we should not decide this question now. So we're basically going to suspend this decision on the ground that it's not right, and we'll take it up again when Trump runs. That was a position taken by Michael McConnell in the Federalist debate. I regard that as suicidal. So you're going to have to go through this entire campaign and not know who's going to be your nominee, and if he's a nominee, whether he's not going to be your president. You're voting on this without having any clear determination. No, you have to decide it now. But there's a chance the Supreme Court will say, oh, it's not right, as opposed to, oh, it's wrong. And, this is absolutely momentous. It contaminates the election in the world's most possible way. And so I think they should basically kill this dragon before it flies, because otherwise you're going to have a situation where 45 states reject the claim, 5 states, including California and New York, accept it, and the entire nation is thrown into chaos. And this is just utterly irresponsible. I mean, I regard this as reckless to the point of national suicide to sort of push these things when, in fact, you've got the first line, and then there are all these other questions which say there's absolutely no provision whatsoever in the 14th Amendment, or Section 3, to have trials undertaken by state courts. Zero, right? And there is a procedure for stopping appointive officers from taking office, and therefore it only applies to appointive officers. You can't have a substantive right for which there's no remedial institution built into the Constitution. So it's point number 2. I don't regard this as just a close case. I regard this as absolutely imperative. I think the arguments on the other side, I've heard Michael Liebowitz make these arguments with Lawrence trial, said, well, you can have multiple remedies for a constitutional violation. No, not if you're going to have this kind of political content. This is a situation where the process has to be regulable, and that's exactly what they did. They were much better lawyers in 1868 than the pack of people who are taking after this statute today.
Okay, I actually want to discuss what constitutes an insurrection.
That's fine.
So I was going to go to something else first, but I think this actually should be discussed first. So what is an insurrection under the 14th Amendment?
Well, I think the first thing it's not is sitting on television and not stopping a bunch of rioters from taking over the Capitol. That is not an insurrection. I'm not even sure.
Hold on one second, Professor, because there's something important, because it doesn't matter if Trump engaged in it. If he gives aid and comfort.
Well, no, that's not. It says the clauses has to engage in an insurrection. The aid and comfort language comes in the definition of what's treason.
That's not in the 14th Amendment?
No.
Maybe I'm wrong. Okay.
No, engagement means involved in. And, there's an argument that was he or was not. The McConnell argument against vote at the Federal Society was he didn't engage in anything that was involved in this particular case, and so that you should just throw him out on that. My view is the engagement issue is much softer and much more indeterminate, just by the definition of the term, than is who is an officer. So I want to describe it on a clean legal ground so I don't have to get into it. But if you're looking at the same stuff, the question is, was there an insurrection? If so, did Donald Trump lead it?
Hold on one second, Professor Epstein. This is the Section 3, 14th Amendment.
Yeah, read it.
It says, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office.
We talked about that.
Civil or military under the United States or under any state who having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as any executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. So
That's
the
the
aid and
definition.
comfort provision is in the 14th Amendment,
Yeah, but the
Section
aid
6.
and comfort provision is a treason provision.
Okay, but it is here. So it has to, you
Yeah, I
can't.
know that, but essentially what they said, you have to engage in getting the
Okay.
guy to commit treason.
Okay.
That is what it means. It doesn't
Okay.
mean, you still have to establish that he was engaged in it. It's not part of engagement, it's a part of one of the options. And
Okay.
that's the whole point. You get three very serious things listed, and then you get a bunch of people who are jerks going into the building and taking selfies. And well, have they engaged in anything that looks like a rebellion? No. Have they engaged in anything that starts to look like treason? No. So now you're going to read the term insurrection to cover ordinary riots. And what the Colorado court did is said any kind of use of force that resists the power of the United States is an insurrection. Well, resisting arrest is sort of denying the sovereign power of the United States. The guys who constantly demonstrated in Seattle and Portland, remember, for weeks, they were never punished for anything. I don't think those were insurrections. I thought that they were riots, and they should have been punished for that, but not by Mr. Garland. So I don't think that. And then, as I mentioned to you, if you start looking at how the term insurrection was used in connection with the Philippines after the Spanish-American War, you had an organized rebellion going on, military guys and so forth. I don't understand what it is to have an unarmed insurrection. I mean, it's just not the way these terms are used.
Is it
Unarmed,
relevant though? Is it relevant? What's more important? How the term is defined now, how it was defined in 1900, or how it was defined at the time that the 14th Amendment was enacted?
well, I think certainly if you're doing this, most people would say it's the time of enactment. The
Okay.
standard rule of interpretation is ordinary understanding at the time that a particular amendment is put into place. And obviously at the Civil War, they weren't worried about little tiny things. They were worried about massive rebellion. Remember, Lincoln goes into Maryland and takes over the place, denies everybody habeas corpus. Why is he doing this? Well, there was a threat that the state would leave the Union, which could have easily changed the balance of the Civil War. Just imagine if Maryland had been on the southern side. Half the battles that took place within the state would now be taking place in competitive territory. It'd be just a huge difference. So he knew what he meant. And that's the definition. You look at the definition when it's applied to the Spanish-American War, they're using the same definition. There are a bunch of guys out there in the field who are trying to kill everybody inside the government. What these guys were asking for is, we want you to send this back to the states so they could recalibrate what should go on in the electoral college, right? They're not asking for the overthrow of the United States government. They're asking for a recount. Now, I happen to think they were wrong on the merits. That is, I don't think that there's anything in the statute which allows the party who opens up the ballots, that is the vice president, to order a recount, because the counting is actually not done by the vice president. It's done by a committee of the House in plain view of everybody else. So what they were really worried about in the 14th Amendment in the old days was to make sure that nothing got slipped into the ballot box in the interim. So he opens them and everybody else checks them. And that's the chain of custody issue, of course, was one of the things that Trump complained about all the time. He said, you got thousands of ballots going out there. They're empty. They're sent to the last known address of a decedent. 10% of those ballots have no home. Anybody could pick one of them up and put them in one of those boxes. I think those are very serious concerns about the chain of custody. And it was what the 12th Amendment was designed to object to. And the idea that somehow or other, when you got a ragamuffin bunch of people, half of whom are just in there taking selfies. It's not as though everybody who moved into the building were after. There were no weapons, there were no deaths, there were no shooting, there was no protracted resistance to authority, no defiance of authority. And then what did Trump ask them to do? He asked them to go and to fight like hell. He did not ask them to go into the building, did he? He did
No,
not ask them to
no,
throw
not
anybody
that I
out.
know of anyway.
No, he didn't. He just
Yeah.
simply said, go and fight for your rights. What he meant, in effect, is go to the Capitol building and stand up and say, we want you to change these procedures. That's free speech. I mean, the ability of these people, he and Fannie Willis, both the prosecutors, to read in a subtext, not verbal, of illegal behavior into something which is perfectly consistent with legal behavior, is to convert what is a constitutional right, if you read it correctly, into an insurrection which is not correct. And they have this, and they don't even get embarrassed about it. One of the so extraordinary things about it, they don't vote the full sentences in any of these things, right? They just give you bits and fragments of it. You look at the Fannie Willis indictment and so forth, it goes on and on and on about how everybody was in this great conspiracy with him. But essentially, what happened is she managed to prove, if you read the statement, Donald Trump, in front of lots of other people, said, as far as I'm concerned, this has been a crooked election because you have to find the votes. He didn't say invent them. He said they've been cast, you have to locate them. That's the way I would read it. And why was he doing that? Because he knew there were irregularities that took place in the Atlanta office. Remember, they shut the thing down. And it turned out it was under the complete control of the Democrats, and they opened it up and they said, well, nothing happened in the end. Well, I think it's perfectly appropriate for somebody to be able to say, this is not quite right. And in fact, my own view about this is I would never, ever want to open up the results again. But I think it's perfectly appropriate for Trump to say, look, I thought I was robbed. And I would like to have an impartial hearing by the House of Representatives to see whether or not the ballot security provisions were satisfied or not, so that we could have new legislation the next time around. But I don't see in that an effort to try to overwhelm the Georgia situation. I don't see this as an insurrection in this case. And I just regard this as a political thing. I mean, what's so ironic about it is, you know, I'm no Trump fan, right? I told you many times, I think, on this show, that I wanted him to leave office as early as January of 2017 on the grounds that temperamentally he's not fit for a high office. Now, at that point, the choice would have been Pence, right? It would not have been Hillary Clinton. I would never urge him to leave to get her as president. But Pence is a guy who knows what he's doing. He's been in the legislature. He's been in the Congress. He was governor of a particular state. Mitch Daniels is his tutor. I mean, you get all the benefits and none of the harm. And that's what's going on in this case. I mean, I would dearly have him step aside for somebody who had conservative, libertarian, classical beliefs like I do, who's not him. But if the choice is him and Joe Biden, I mean, classical liberal, Joe Biden, guy who never violates the rules for political advantage, Joe Biden, guy who doesn't have a whiff of production, so with his name, Joe Biden, a guy who doesn't have an attorney general who protects him from all things greater than Joe Biden. I mean, that's the lesser evil choice. But I think, in effect, taking Trump off the ballot is, in fact, the most anti-democratic thing that could be done. And of course, the Democrats, in a burst of pious virtue, have sort of announced that they're really morally bound to do that, just the way the Colorado court said, we have to do this, and then writes an opinion which can only be described as shockingly inept and thoroughly one-sided. Why one-sided? I've mentioned a lot of arguments to you here today, right?
Yeah.
Have any of them ever was a single one of them addressed in that opinion?
Not that I remember, but the
The
opinion's
answer is you
very
don't
long.
remember what wasn't there.
Yeah.
Because
I remember the one of the dissents mentioned what I'm going to ask you next. But I just wanted to give you your objectivity bona fides here. That you're no Trump fan is you've also said that you believe he's got real problems with the documents case.
Yeah.
So you don't just defend him. You're not one of these Trump defenders. So
No,
you're right
I mean,
about
look,
that.
what you have to do is take every case on its own bottom. Now, I mean, the issue with respect to the papers, and we're sort of coming to the end of all this, is pretty simple. It's tragic. You want to figure out who's a real disaster on that, it's Hillary Clinton. Remember, all this Trump stuff is documents were lit around. He shows them to somebody. She has them accessed on the interim. She's Secretary of State at the time. Everybody can steal from them. He's got a bunch of things and he holds up a document in front of somebody else that they can't read it. They certainly can't strengthen it. And everything that's in those documents is probably obsolete because foreign policy moves and you've got, 24 months between what happened there and the time that these documents were involved with. So, I mean, look, I think if you didn't go after her, it's a little embarrassing to go after him. And I thought that the utterly disgraceful privileges that were given to her in 2015 to avoid any hard questions, that was a real source of genuine outrage. So, I mean, I think, in effect, that there is a democracy deficit on this side. And so I'm going to ask you the question, because you're also an equal Trump fan like me, right? Equal non-fan. Did he ever initiate any prosecution which was as dangerous as the prosecution associated with the Mueller papers and all the other stuff that was done against Trump and Flynn and all the other people? I can't think of a single case in which he actually brought a criminal action against anybody that would be suspect. He just blathered a lot, which is not
Well,
quite
that's
the same
true,
thing.
but there's also some indication that there were people holding him back.
Yes,
Where
I agree,
yeah, that there's people
but that
holding him
shows the
back.
system
So
works. I
it
agree. I
does, but
mean,
it won't be if he gets in again because they now
well,
have
that's
this
another
plan, and
question.
that's a problem.
I agree it's a problem, but it's not a certainty.
So
I mean, that's
go
the
ahead.
problem with Trump. That's why I don't want him to get the power. I think he's too erratic. I said that in 2017.
I
But
think
I
it's a
mean,
problem with our whole system right
yeah,
now,
but
really.
Joe Biden is, he's barely
He's
compass mentis.
incompetent. Yeah, he can't even utter a complete
Yeah, but I mean,
sentence.
he can't do anything. And he's led by, well, who do you think is the most powerful person in the United States now?
I think you're going to say Obama.
No, I mean, no, those two don't like each other.
Then Jill Biden.
Yes, I think it's probably Joe Biden. This is like Edith Head after Wilson became incompetent. You get the wife of the president running the show and aided by a bunch of people. A lot of them are Obama holdovers, but the same thing is true of the holdovers, which is true of Obama. Namely, they've all moved very sharply to the left since Obama left office in 2017. So you're not getting the same crew. There's none of that self-constraint. Just look at the way in which he appoints judges. I think, what, 40% of his judges are minority groups, most of whom are Black women. I mean, it's really quite an extraordinary sort of situation on this. He's a regular backer of DEI type institution. The guy who runs the Lloyd Austin does exactly the same thing with the Service Academy. I mean, I've litigated against the president, and he's absolutely lawless, as far as I'm concerned, in the way in which he deals with people on independent agencies and advisory boards. He just fires them as if they were his personal servant, and the courts thus far have let him get away with it. So this is not a question of guys who are lawless against guys who are not lawless. There's a terrible mistake in the American system in which senility seems to have a huge preference, right? Older candidates is against younger candidates. And when you run a primary system, you get the median voter in two parties that are split, so the candidates are much further from the center than in the old days where they were picked in a smoke-filled room. So you're faced with a lot of unappetizing choices. Who would I put amongst the Republicans? I don't want to really say on that. I mean, I think the one who's most likely to, if he's going to be deposed because of either this or something else, gets a stroke or whatever it is, God forbid, it's going to be most likely Nikki Haley. And she is, to some people, too much of a trimmer and a sensitive. So she's not going to get all the Trump vote automatically. You agree with that, I think.
Yeah.
I mean, she's going to get some of it, but there are going to be other people out there in open rebellion. On the other hand, it seems as though DeSantis can't get anybody who is not on the hard side. And all the other candidates, they just can't, they don't register.
No.
I mean, Swami's a smart guy. I mean, I know him. Right. But he's always regarded as too immature for the job. And DeSantis, he basically keeps stubbing his toes on foreign policy issues. And he picked this senseless fight with the Disney operation about the financial arrangements and the self-governance provisions, which were actually pretty good procedures. I mean, it's Michael, politics is picking candidates with warts. Was one of my late friends, Michael Levine, always said, and I always like to close this line. So when you're engaged in practical affairs, you have a ship and it's floating. And the question you ask is not, is it whole absolutely sealed? The question you ask is, how many direct shots can it take below the waterline and still sail? And the presidents are like that. For every person who has a brain, every presidential candidate is to some extent wounded. And so you have to figure out which wounds are the greatest wound. And what's happening is, as this thing continues to degenerate, the wounds get larger on both sides.
Well, good thing for me, I can't vote as a convicted felon, but
I know.
I wouldn't vote for either of them. That would just be, it's a personal decision, and I don't begrudge
As
anybody.
I said, that's
Yeah, it's tough.
It's
it's a
not,
tough
you're
spot.
not voting for the lesser evil.
No.
And I don't ever try to persuade anybody on that formal issue.
Those are tough decisions.
Yes, but it's also, I mean, the idea that Joe Biden embodies ideal democratic policies. He's
no,
a high-handed arbitrary dangerous
I'll,
individual.
I'll never forget during the debate, and I rooted for Romney. Back then, I was a lesser of the
Yeah,
two evils guy, and I remember Joe Biden's debate, the vice presidential debate with Paul Ryan, and the way that he
yeah,
conducted himself in that debate, I thought was disgusting. I thought he was just he showed himself. He did in that debate to Paul Ryan what Trump did to him this last
yeah.
time around.
And
So
of
I
course,
didn't feel
Trump,
any bad for him or
I
anything
mean,
else.
and the irony, of course, is why did Trump behave like such a buffoon? He listened to, of all people, Rudy Giuliani.
Yeah,
I
another
mean, that's the
buffoon.
case of, you ask, are these, this man was a hero in 2001, right?
He's thrown away his whole legacy.
Yes, absolutely.
Yeah,
And,
totally.
and Trump could do that and Biden could do that. Obama, if he were ever reelected, would do it again. Right now, I'm suing him as well. You know that. Um, Both presidents, because of the overruns with respect to the Obama Presidential Center, which is an environmental disaster, which is going to cost the city of Chicago over $1 billion if they actually complete this building, in order to preserve his vanity projects and so forth. I mean, I always like to say about Obama, he's not a graceful ex-president. George Bush, W. Bush, is a graceful ex-president, right? Jimmy Carter, pretty much a graceful president. Gerald Ford was a kind of a graceful ex-president, as was, I think, George H.W. Bush.
Sure.
But Obama, he always reminds me, this is Prince Harry. He can't get out of the publicity, and every time he gets in it, he doesn't know what to do. I mean, it's Michael Jordan. It's Tiger Woods. What you have is you have a huge day in the sunshine when the time has passed. You know what you're supposed to do? Just
Go
get
off
off the
and
stage.
go off into the sunset.
Yes,
So
that's good.
the Fifth Amendment to the United States Constitution, and it's in the 14th Amendment too, says that a person cannot be deprived of life, liberty, and
In a
property
process without due
with due
process of
process
law.
of law, right? So there's an argument being made that by depriving Donald Trump of his right to run for president, he's being deprived of his liberty. He hasn't been given due process because he hasn't been found guilty of the insurrection. Is
Well,
the liberty discussed in the Fifth Amendment? Would that be covered? Does that cover not running for political office?
nobody knows. The original debate was over the following proposition. If you took the famous statement by Oliver Wendell Holmes, liberty simply meant the freedom of locomotion. You could go here, there, and the other place, and they couldn't lock you up or block you from going. Then on the other side, the issue was that the freedom, liberty included economic liberties to engage in various kinds of transactions. Still not the political liberty to run. And the difficulty that you get with the political liberty argument is, what about standard eligibility requirement? Do you deny somebody a particular right if they've been a criminal or something of that sort? I think the usual answer to that question is no, there is not a liberty issue to run for president. What there is a kind of an equal protection right that the standard norms that applies to everybody else applies to you. That's the first problem. And it's tough. I mean, that's close. But they did have a trial, if you remember, right? And she gave a decision as to what she thought. So doesn't that satisfy the hearing requirement? Well, there's a long literature of what it is that counts as a hearing that satisfies due process, and nobody knows how it would apply to a case like this. What was really extraordinary about the decision is that when they got to the appellate level, they said, well, lots of people could disagree with what she said, judge down below. And there's a lot of evidence going on both sides. But we're an appellate court, and we look at all questions of fact with the idea that they're fine unless they could show clear error. So essentially, she deferred to it. So if this thing stands, it's a trial judge decision, which people back off on the appeal level, becomes decisive in the presidential campaign. Do we really want a system in which a trial judge who doesn't know what she's talking about, arguably, is the person who decides who is not on the ballot? I mean, it's just grotesque. I mean, most people who look at this, even most independents, think it's crazy. There's no doubt that this will essentially, if you're trying to count votes, it's going to help Mr. Trump. It's not going to help Mr. Biden. He's now looked at as a thug for supporting this. And of course, he says it's perfectly clear there was an insurrection. Just look at it. He doesn't give a definition. He doesn't talk about the facts, doesn't talk about whether it was a Trump-initiated thing. There's a lot of things to look at. He's a shameless provocateur. And he's every bit as irresponsible about this, maybe more so than is Trump. The reason I have some sympathy for Trump is even though he's immature and whenever he's hit, he's always whining instead of talking. I think he's right. I think they're after him. And I think it's very bad when you get after somebody politically and legally because you don't want him to be president of the United States. And that's what they're doing to him. And I think it's perfectly obvious. You read the New York Times and all of its editorials. I mean, they're literally salivating to get his scalp up on a pedestal one way or another. And that's pretty disgusting. I mean, I am, just for the record, not in favor of impeaching Joe Biden at this time. I wouldn't want to do it even if I thought the evidence were overwhelming, which it's not quite, but it's certainly very strong, much stronger than the evidence against Trump for the 2 impeachments that were raised against him. I just think it's too disruptive in a presidential year to have that kind of silliness go. Okay, Michael?
Okay, beautiful. Is there anything that I didn't ask that I should have, or anything that needs to be said about this that
You
we
didn't
did
ask
not
about
cover?
you didn't ask about my blood pressure.
How's your blood pressure doing?
Well, it always goes up when I do these shows, but it goes down when I start to do something else. Okay,
Well,
take care.
thank you very much. For now, this is the Rational Egoist signing out. This is Michael Leibowitz. Till next
Bye-bye.
time.